So he's not going to be here. So we'll just do a regular reset, just 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry I couldn't hear you.
Happy Monday.
Oh, happy Monday.
Have one of our trial cases tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony. And if not, I will announce not ready, mostly because I got texted some videos last night.
Quick legal note here. A reset basically means pushing the case back on the calendar. It's common in busy dockets. But here's the question. Do resets really serve justice, or do they just drag things out? What do you think? Efficiency or delay tactic?
I got emailed some videos.
Let me pull them up real quick. Hold on.
I feel like he was dismissal if he pled the felony, and then I think they rushed the felony.
Judge, do you have the case number?
I do.
Okay.
502-101.
N02.
You know, they reset it. Let's see, 219.
Yeah. The problem is I have they all overlap, and I swear I have 2 reckless drivings, each of them with a gun. One of them called my office to say he pled. I guess it might have been the other one.
Our gun case pled. The reckless driving is still open.
Okay.
And then it looks like the felony evading in the vehicle resets at 219.
All right. Let me hold off on that till tomorrow, Judge. Because I came in here thinking that they had pled upstairs, and I obviously got the guy confused who pled upstairs. So let me make some phone calls. The client called me to say that he had pled, and I thought it was this one.
What are they doing upstairs? Any news?
We're in touch with defense upstairs, and they are going to take, the defendant is going to take the deferred and felony and then dismiss our cases, adding the condition about the firearm, I believe.
Yeah,
They're doing a TRAS? Is that why they did the reset? Are they doing a TRAS upstairs? Is that why they did the reset? Because a lot of times prior to a plea, they'll do a TRAS.
Yeah. Reset from the last setting without actually agreeing to plea. Kelsey then sent out the email, hey, will you do it? They agreed to plea. I thought my client called me to tell me that he had done the plea. I think he has now agreed.
Did they do the TRAS? They just set for this to do a TRAS?
They hadn't officially done it yet, sir, but I'm talking to felony defense counsel, and we were hoping you could just come do it tomorrow when this one's.
The judge just admitted the reckless. Driving didn't even look that reckless on video. Isn't it wild how perception in court can shift everything? A case that sounds serious on paper might look totally different when the evidence rolls in.
When this one's set for trial, but we wouldn't actually be going on it because that was the agreement.
Bless you, wherever you are.
Is he in custody?
No, he's not.
I'm looking at I'm just looking at.
I will say I got the cell phone video that was emailed to me yesterday, and it's not particularly reckless. Yep, the donuts, there's good distance between him and all the other cars. Shush.
On the reset, they didn't mark anything, and then on their settings, it's just a non-trial setting.
Well, so they reset it, and then after they reset it, Kelsey, and I'll give it all credit to Kelsey, sent all the emails and got everybody to agree to take the plea. So all the paperwork was before the defendant agreed to take the plea.
You said you want to set it for tomorrow?
No. I thought he had already taken it, and I think we're set tomorrow.
Right.
So I can have the
Want to
client
go ahead
in
and set it?
Well, I can walk him up to felony court, consider the fact that I'm not his felony lawyer, so I can't take the plea.
I'm not asking you to do that.
No, what I'm saying is I
Hey,
can't
set it
normally do
to
that.
the felony.
Oh, yes, please. But I would say leave it for tomorrow, because I don't want to communicate with the client. If he's not set tomorrow, I might not be able to get a hold of him. He might come in anyway. So if we leave it tomorrow, he comes in, I say hello, and then I set it for the day to felony.
So what if he doesn't show?
Tomorrow? Oh, cup to the beans.
So I revoke it?
I would hope not, but that's a conversation I'll reserve for tomorrow.
What's...
Yeah. You take it. Thinking 2 steps ahead, but like kind of in a lateral direction as well.
Yeah.
I know. But right now we have a resolution. It's plotted out. We're going to get this resolved.
With you.
I'm choosing to think positive. Also, I'm trying to suck up to this one because I need a time served offer on a different case. All right. Thank you, Judge.
Morning, Mr. Harris. Mr. Harris, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case. Meaning that you ever pick up another one of these cases, you will be facing third-degree felony. Minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a Batters Intervention Prevention Program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick
Listen
you out.
closely. This is where the stakes skyrocket. One wrong move in this probation program, and it's straight to jail. Imagine the pressure of knowing a single missed class could completely flip your future.
They're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation of conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? Weapons, no. Harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick. Sign up. As soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. Be nice to everybody and just don't get positive. You understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you're stuck with this until you complete it or you get revoked. You understand? How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold it for 15 months. Do well. Done. 7.5 months. All right. Good luck. Then, what do you do? What do you do? Say it again. Okay, what do you do for a living? Okay. How many kids you got? Okay. Reduce the fees. Yeah. I'm trying to find out. So I'm going to reduce the fees so you don't have to just pay a ton of money for supervision and stuff. My concern is more that you get the classes done, learn from this, so you don't end up with a felony, you know? So, all right. Good luck. Please. You're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
You also spoke with the complainant in Spring High School in Harris County, Texas, and the officer retrieved a video footage of the
This part
event.
is crucial. The judge is making it crystal clear that bond conditions are not suggestions. They're survival rules. One slip, one text, even showing up at the wrong place, and you're back behind bars. Question for you. Should bond rules be this strict, or do they sometimes go too far?
Of the event. The video showed the defendant turn to the camera, stating ready, and then began striking the complainant multiple times with a closed fist to her head and face as the complainant falls to the ground. The complainant stated she felt pain and showed multiple signs of redness on her face.
Okay. It's in the actual high school, huh? Okay. Ms. Barrett, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? I want you to listen, because these are your bond conditions. If you violate these conditions, I'm going to put you in jail. I'm also ordering you not to be in possession of weapons as well. Do you understand? Do you have a lawyer today? Would you like me to appoint you a lawyer? Can you file those conditions, please, Alex? Okay. So what I need you to do, ma'am, is, are you 17, 18? You're 20? Are you actually in high school? Are you, you don't go to this high school, right? Stop. I'm only asking you. Then you're not to go back to this high school. Do you understand? All right, so I need you to fill out an application for me. Deputy's going to give you an application, and then I'll have you talk to a lawyer here momentarily. Do not leave until you sign our bond conditions, all right? I don't care where you live. I don't care what you do. You are still under bond condition of this court. If you do not have a Texas driver license, and if you do not have liability insurance, you are not allowed to drive. Do you understand? I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does that here, they come into here to downtown and they take a test, and I pay for it. Because you're over there, I cannot pay for it. You will be required to fit the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission, and you spend any more than 46 hours in custody, you will probably get an immigration detainer, and it's not going to go well. So, if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
The next one, Your Honor, is
Stick it.
These also do not see that change the location of this unit. And I wonder about
Where does he live?
happening, Judge. It seems like
No.
right now,
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it. I don't know him. I've never met him. And so, right. I'm just doing everything that I would do to every single other person. Yeah. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney
This is
present.
huge. The judge just found no probable cause. That means the case basically collapses, at least for now. But here's the twist. Do you think hanging around the wrong crowd should put you at risk of criminal charges, or should the law draw a clear line?
Attorney present, if you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. The witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and following the stop in Pantoja, was observed unloading items from the U-Haul, ran to the back of the residence, preventing officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions. I don't even know where to start.
my concern is, only I want to make some points of argument for detention. The first one, my concern is that the 911 caller mentioned unknown marks. Police officer later mentioned them as suspects. Without any type of articulable facts, believe they are the specific people because the individual perhaps is an issue. Now, since we know probable cause requires more than a hunch, more than suspicion, it requires something else, more than that. And it seems that that's all that we did, at least. I mean, the four corners of the thing that led that my client was
Well,
involved with that.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Judge.
and they've given the description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Sarah remained in the U-Haul. There's no further information regarding Sarah.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck? Was driving the U-Haul? How was he engaged in this alleged criminality? Like,
Your Honor.
just does mere presence impute criminality?
And that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
So,
We're not arguing against it, Your Honor. Like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have time.
no, but I'm not going to sit here and hold someone.
And that's why we defer to the court.
Look at what the statute says. You know, a person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or is a member of a criminal street gang, person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as is pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence and the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, we could just, when we said early personnel, we called the witness.
He's in custody, you know, and I can't. I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him
And there
just.
it is. No probable cause again. The judge basically says, I'm not holding you without real evidence. But notice the warning. Be careful who you hang out with. Sometimes your circle can decide your future more than your own actions.